Miss Bates lied on the stand according to the 911 call. Oh, he had a gun. He was kicking in the door. When asked at a minute and 30 seconds in, does he have a weapon? No. That's what she told the 911 operator. Did you see a gun in the video? You saw him knock. Did you see a gun? No. Did you see him kicking the door? Trying to bust down the door? There would have been evidence left on that door. A dent, something? No. There was a brief talk about, and I don't know the exact date, so I'm not even going to say that prior someone had busted in. But there's no phone records. We have all of these phone records about where Miles Bryant was. Even if they didn't have enough for a search warrant then, surely on this case they could have gotten a search warrant. No phone records to show that he was tied to that at all. She had him labeled as a stalker in her phone. That could have been changed anytime. We all know you can change your profile picture day to day to day. Why not show us the text messages? We saw what, 3 pages where he's like, you know, you want to hook up or whatever. Why is it whenever he talks about, I think it was moonshine or some sort of alcoholic beverage, LMAO? Is that what you respond to a person that's stalking you? That doesn't make any sense. We don't have the text messages. Never told him to stop and never blocked him. In fact, she wanted to lure him over to her apartment to get evidence. If you're afraid of somebody and somebody's stalking you, you block that person. You block their number, you change your number, you go take out a protective order. Never told him to stop and never blocked him. In fact, still had him on social media, because I believe that's where she said she posted a little video about him leaving. That makes no sense. And we know that this was investigated by the Doraville Police. Again, volumes and volumes of paperwork. We didn't hear from the Doraville Police. And we know he was still working there. Talking to the 13-year-old. I expect the state is going to come and run this into one statement. But if you listen to that, there were different components to this. First, someone could pick you up and rape you. Conversation, conversation. Find you in the woods somewhere. Conversation, conversation. Throw you in a van and we will never find you again. Further down in the conversation. And think about that. As an adult, when you're fussing at a child from running away, that would be exactly what you would say. Somebody could pick you up and rape you and dump you somewhere and we'd never find you again. What does that show? What do any of these show? So this is what the court instructed you on before that evidence came in. You can't infer from this evidence that he is of a character that would commit such crimes. They're just being offered to show lack of mistake, intent, motive. But what does that show? Does it show kidnapping? Does it show murder? Does it show intent to rape? No. It just makes Miles look bad, which is all that they can depend upon since they have no evidence of malice murder and no evidence of kidnapping. Reasonable theories, which were actually brought up during his interview. Did she overdose? We possibly could have had evidence from that, And I'm going to go into that in just a little bit, but we don't. Took off the puke-drenched clothes before putting her in the car. Zenobia confronted him, thought he was with a girl. Jealous, busted out his mirror. His other girlfriend corroborated that statement that he said during the interview, that he did have a busted mirror about that same time. What happened between 10:07 and 10:21? What happened between 10:21 and 10:29? We don't know. When you're back in the jury room, I'm sure that you can come up with a reasonable theory. Basically, the state has come up with a reasonable theory. The bottom line, the state's case is a theory of what could have happened. And all their evidence is tailored to that. Like when Biggers was testifying, oh, you could see directly into her house. How long had they lived there? How long had Miles lived there? Would there have been a time where he would have had that same view? Back when this happened, we know that all the trees had their leaves on it. Could you have seen during that time? We don't know. They themselves gave reasonable theories during that interview, based upon the evidence that they had. Him being in the woods and his gun being found there. Did she overdose? Did Zenobia catch y'all and something happened? Were you having a relationship with her and Zenobia came up? Whatever. But if there is another theory, it doesn't have to be more probable than something else, but any reasonable theory means you must find him not guilty. We don't know if she overdosed, and we could have. It was never treated as a possible overdose because of the body being in the woods and not having clothes. However, we could have known what she was on that night. No bone marrow testing.
No, I'm going to object at this point. Dr. Terry was on the stand. Ms. Ray could have asked her all these questions, but the facts not in evidence in strict notice.
And I'm gonna strike that.
Your Honor, they did recover hair.
I understand, and Dr. Terry was here and her assistant was here, and you could have asked about those tests. So I'm not gonna
We
allow
don't
you.
have any results from any testing.
Ms. Drake, you could have asked if tests were done. And you didn't. So
If there was
I don't want to stop you in your closing again, but you have to rely on the evidence in this case.
They had hair. No cause of death. And it is completely speculation at this point. Unfortunately, we don't know how this young lady died. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory. Are there other reasonable theories? Absolutely. After giving consideration to all of the facts and circumstances, the Life 360 compared to the walking video, the breaks in time, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law. This is what this case is. Grave suspicion. And the court is going to instruct you that facts and circumstances that merely place on the defendant a grave suspicion of the crime, or that raises a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction. This case was very, very emotional for everyone involved. But the judge is going to instruct you that you cannot consider sympathy My heart broke when Jasmine and the mother were on the stand. I have daughters. Some of you may have daughters. That is the worst nightmare. The fact that he left her out there is one of the most disgusting things I've ever heard in my life. No matter what happened to her. That they went through 7 months of searching for her. That Detective Carter, I mean, she was on the stand for a long time. She worked hard on this case. Biggers worked hard on this case. All the police man hours. But all we have is grave suspicion. It's okay not to like Miles. Think he's disgusting, thinks he's a terrible police officer, whatever. It's okay. And it's okay to feel sick when you realize that there are other reasonable theories and that you have to return a verdict of not guilty. Now, during jury selection, we always ask questions about leader versus follower, analytical, work in HR, supervise people. And oftentimes jurors have always asked afterwards, I was wondering why y'all ask those types of questions. It's because, especially in a case like this, where the emotions are so high, we need people who can make tough decisions. Decisions that you may hate to make. The truth of this case is we just don't know. We just don't know. Now, the state, sometimes, it's been a long time since I've had a case with these prosecutors, oftentimes they'll get up and say, it's not your job to seek doubt. I disagree. How do you know that there is doubt if you don't go through it all and seek doubt? Maybe, could haves, grave suspicion is not beyond a reasonable doubt. I urge you to listen to the law as the court gives you. Go back in the jury room and think about this case. It is very important, not only to the state, not only to Susana's family, and regardless of what you think of him, it's very important to that young man right there. Is there another reasonable theory other than what the state has presented? Is there any evidence of malice and murder, an intent to kill? Is there any evidence of intent to kidnap or kidnapping or of rape? There is not. And based upon the law and the facts of this case, the law compels you and orders you, pursuant to your oath, to enter a verdict of not guilty, except for count 5. Thank you.
Ladies and gentlemen, I do expect the state's closing to go at least an hour and a half. Would y'all like to take a 10-minute break? Okay, let's take a 10-minute break, and then the state can close.
Look at this priest sitting there like this. Look at him. He was going to testify. The lady that you see right there, that's Susana's sister, her big sister.
Mr. Bryant, no, come back out here. Mr. Bryant, during your attorney's closing, I asked the attorneys to approach It is not my policy to interrupt in closing, and I prefer to have no objections, as I'm sure both parties. But there were some objections drawn, and I asked the attorneys to come to the bench. And I told Ms. Drake that she needed to use the evidence that was presented at trial, that I didn't want to have to stop her in front of the jury, which I did later. And the objection, I believe, was drawn when she stated that you were terrified. And the objection was that that was not a fact in evidence. And I brought the parties up because I don't like to disturb closings. That was the only bench conference we had during Ms. Drake's closing.
Yes, ma'am.
Okay. Is that correct, Ms. Drake?
Yes, ma'am, it is.
Is that correct, Mr. Delphine?
Yes, Your Honor.
Okay. All right. We'll be back in
And
10
Your Honor,
minutes.
I believe the state had another issue.
Oh, I'm sorry.
It's just on the jury charges, Your Honor. Mr. Drake, in her closing argument, I think probably copied and pasted from the charges that are going to be given on there. So I didn't have any objection to that until I read it and realized that there's an error in the charge. And so on page 9, for the charge on other crimes, wrongs, or acts, in the second paragraph, and I'll wait till you get there. It says, it should say in order to prove its case, but that's not the biggest issue. The state must show intent and identity of the perpetrator. The charge that was given actually on the limiting instruction for the 404, and the reason the court admitted it is for intent and motive.
Right.
Identity is a reason under 404B that we can admit, but that's not one of the reasons the court actually admitted the evidence for. And so Ms. Drake's slide, actually, I think copied and pasted this exactly. I didn't want to object at that point because we could address it now when the court charges the actual jury. But I think we should remove identity of the perpetrator and replace that with motive.
Okay. So we're going to replace it. In order to prove its case, the state must show intent.
And I think it's may show.
It may show. Yeah.
And identity, because we
Yeah.
don't have to show that with 404B evidence. We may show intent and motive.
May show intent and motive of the perpetrator.
I think I'm wrong again. I think it actually needs to read, must show intent and may show motive.
Right.
I think that's the correct.
Everybody has to be seated in the courtroom. Be seated in the courtroom. You have to be seated in the courtroom. You cannot be in the courtroom unless you're seated. Okay. In order to prove its case, the state must show intent. And we've got the last sentence, may show motive.
The language that's in the limiting instruction, I think is perfect. It says, in order to prove its case in counts 1, 2, 3, and 4, the state must show intent, period. The state has offered evidence of other acts allegedly committed by the accused to prove intent and motive and negate any defenses of accident or mistake. And so you might just copy and paste that portion of the limiting instruction into the top here.
Okay.
I think the biggest issue is that identity is not.
The identity. Right. Right.
I don't think that's an issue.
Right. I mean, you agree with that.
Oh, yeah.
Yeah, that's just a mistake in the charges. Okay. I'm going to get the charges changed, and I'm going to take a 10-minute break now. I'll give y'all 10 minutes.
I wonder who this is. Is this his family? What is this family? Don't look like the mother. Wonder who it is. Okay, they on this 10-minute break, so we'll just wait until they come back. Working from home today, so I was able to stream this in the daytime. Woo, boy. Let's see the closing arguments. But I will be going again live later on tonight because I want to do the interrogation or the body cam, something, whatever. But we have to see what the verdict is going to be. So I'm just going to have it on mute until it comes back, but when they come back, it will be on, you'll hear the volume. And make sure y'all hit the like and vote. Emmanuel and Kendall. Ladies and gentlemen, today is the closing arguments. Anybody who's just coming in, they're having closing arguments and they're on a 10-minute break. Defense did their closing argument. Yes, defense did their closing argument, so we have to wait for prosecution. So they should be back in a few minutes. Make sure you hit the like, and thank you for being here.
Action was for you to say he was terrified because that was not in evidence. What was in evidence throughout the interview was that the police officer said he was nervous and he appeared nervous. But terrified is that he was terrified was not in evidence.
Nervous, scared.
And you went on to say those. You went on as soon as I stopped you, you went on to say he was very nervous. He was shaking. They said he was shaking. He was nervous. Who wouldn't be?
Right, but I think it's a reasonable inference that he was scared
Okay.
as well.
I understand the objection. I appreciate you putting it on the record.
Okay, thank you.
Anything else from the state before we bring the jury back in?
No.
Okay. Anything else from the defense?
Oh, no, ma'am, thank you.
Okay. And Mr. Bryant, before you came out, I asked your attorney and the state's attorney to make sure that page 9 of the jury charges was corrected. It came up, I believe, based on your attorney's closing, drew the state's attention to it, and we corrected it to the satisfaction of both attorneys on the record right before you came out. So let's just do that again. Are the jury charges correct, Ms. Drake?
Yes, ma'am.
Are the jury charges correct, Mr. Delphont?
Yes, Your Honor.
Okay. All right. Anything else?
No, Your Honor.
Okay. All right. We'll bring the jury back in.
Yes,
I'm leaving the lights up. I'm assuming you want them, you and Ms. Drake them to see you. Yeah. That's why I left them up.
Welcome everyone to Donna Just Being Real. Make sure you hit the like, share, and feel free to comment in the comment section. This is Creep Trial, Miles Bryant. This is closing argument there.
Ladies and gentlemen, I'm sorry I kept you a little bit longer than I said for that break. We had a couple things come up that we had to deal with before the state presents its closing. All right, you ready?
Yes, Your Honor. Proceed.
Absolutely.
This badge is supposed to stand for something. It's supposed to stand for the obligation somebody takes to serve and to protect their community. Every officer takes that sworn statement. It's on the side of police cars. They are to serve and to protect. That flag, the United States flag, means something. When somebody in the National Guard takes an oath to uphold and defend the Constitution of the United States and the laws of our country and the laws of the state of Georgia, it means something. But to the defendant, it meant nothing. He took those oaths, and as you've seen through the trial, violated them time and time again. He didn't serve, he didn't protect, he abused. He took his power, he took his badge, and he used that to violate the law. He used that to murder. He is a cop turned killer. I told you in the
Yes,
opening,
he is. Cop turned
there is
killer.
nothing hidden that will not be disclosed, and nothing concealed that will not be known or brought out into the open. I am certain that the defendant hoped this would never come to light. Hoped that nobody would ever find his gun laying in the woods next to Susana's murdered body. But the reality is it has come to light. And he faces justice now. Despite having hidden, covered up, lied, stolen, he faces justice now before you. Ms. Drake went over some of the law. The judge is going to give you this document. This document is 21 pages of the law. It's going to charge you about every area of the law that you should consider. Ms. Drake went over several of those. And I want to point out a few that I think are important. I don't want to spend a lot of time on them because you're going to have them. You have a copy of them, each of you will. You'll be able to read them exactly and precisely for yourself. But there are a few tenets of the law that form and frame how trials happen, how you should consider the evidence in this case, what your obligations and responsibilities are. The charges in the indictment, malice murder. What does it mean? What is malice murder? We oftentimes, in Georgia, we have a unique system. We have two different charges for murder. It's malice murder and felony murder. In other states, you may hear first or second or third degree murder or premeditated murder. Those don't exist in Georgia. There are just two. It's malice murder and felony murder. And both of them are charged in this case. And I think it's important for you to understand what those mean and what the elements are. Here it says, and you'll have this charge in the jury room, it says exactly this, that it requires that you find the defendant caused the death of Susana Morales. He did so unlawfully and with malice aforethought. Right? That's a legal phrase. It's in the law and it's in the statute. It says malice aforethought. But what is that? What is malice? This is what it is. It's when someone acted with deliberate intention to unlawfully take the life of another person. You'll read in there, it's not premeditation. It doesn't mean that this had to be months or weeks or days or even hours of premeditation. It means it can happen in a moment. But it has to be intentional. Right? And that's what malice means. You're going to get the full charge in there and you can read it. In this case, we believe that the defendant acted with malice, that he intentionally took and snatched the life of Susana Morales on July 26th of 2022. There is felony murder. Felony murder happens when somebody causes the death of another person while committing a felony. And it doesn't require malice. You don't have to find that he intentionally did it. It could be accidental. In felony murder. It could be an accident. I didn't mean to kill her, but in the commission of a felony, she died. That's the definition of felony murder. It's charged in all kinds of instances. In this case, it is charged that he kidnapped Susana Morales. We're going to get to the fact. Ms. Drake brought up that there's no evidence of kidnapping. And I strongly disagree. And I will show you exactly what that evidence is. But the felony that the state has alleged is that the defendant was committing kidnapping. He took Susana. He took her, he threw her phone out of the car, and he ultimately drove her all the way to Tequila, and where he killed and dropped her body. That is kidnapping. And if in that process of kidnapping her, she dies, that's felony murder. That's the definition. Kidnapping means to abduct or steal away Susana without his authority. Without his authority, without lawful authority. Not using a badge, he didn't arrest her. There's no police report. He didn't arrest her or lawfully take her with his badge as a police officer. Unlawfully, without authority, took Susana Morales. Held her against her will, and it caused any sort of bodily injury. It could be a scratch. In this case, it's her death. Attempted rape. Rape is a pretty obvious crime and what it means. It means to forcibly have sex with a man, forcibly raping and having sex with a woman against her will. Right? And there's a charge on it in there, the full definition of what rape is. What is attempted rape? What means you attempted to do that? We don't have to prove, and we're not alleging that he followed through, that he actually did. And as we'll get into it here, the reason we didn't allege that is that over the passage of 196 days, Susana's body completely deteriorated. She was 100% skeletal. Couldn't recover semen. You can't recover forensic evidence of that nature on a body that's completely skeletal. And so there is no way to prove that he actually raped her. The charge is attempted rape. And what attempt means is that you have to commit some sort of substantial step to further the crime. Right? I can't just think about it. It's not just a thought crime that he wanted to rape her or that he thought about raping her. That's not enough. Attempted rape means he took a step towards doing it. And here, the step is that he kidnapped her. And as we'll go over here in just a little bit, her body is found completely naked. No clothes whatsoever on her body. And lastly, false report of a crime. This requires that he willfully and knowingly made a false report of theft to Officer Merkley with the Gwinnett County Police Department. Ms. Drake told you he's guilty of that. Right? That might be the easiest obligation you have, but it's significant that she said it. Right? We're gonna watch portions of this interview. You're gonna get to see here in just a second again what he said, but he lied repeatedly, over and over and over and over again to detectives. Not just one detective, not just two detectives, not three, 4 detectives. Lied for 3.5 hours about, I didn't drop the gun. It was taken. I promise, I wouldn't lie to you. What you will see at the end of this case is that the defendant doesn't know how to tell the truth. Everything he says is a lie. Everything in the interview he said is a lie. And if he's lying about that, ask yourself, why is Ms. Drake admitting that, but not any of the other stuff? There's a charge on reasonable doubt. This encapsulates this entire process. Reasonable doubt. The state's burden, as Ms. Drake pointed out, in every criminal case, whether it's shoplifting or murder, is that we have to prove the defendant's guilt beyond a reasonable doubt. Right? It's such a common phrase that it's ingrained into most of our minds, and in our daily lives we hear that phrase. And oftentimes we misconstrue that phrase. What does it actually mean? Oftentimes we use it in common vernacular and daily life to mean that we got to be positive, right? We've got to be 100% sure and certain of things. But that's not what it means, right? And in fact, who's really 100% certain of anything in life, right? There's an old adage, the only thing certain is death and taxes, right? But even that is somewhat of a joke, right? Being 100% certain of anything in life. Am I 100% certain that after this I'm probably going to go eat? No. I would like to think that maybe I will, but I'm not 100% certain of that. And the reality is we're not 100% certain of almost anything in life. That's not what reasonable doubt means. What it means is a doubt based upon common sense and reason. You're going to get the full charge. You can read it. It is, as was previously stated, a doubt of a fair-minded, impartial juror honestly seeking the truth. Right? But a phrase that is very important here is common sense. I'm going to explain to you why that's important. It also means not beyond all doubt. It doesn't mean that you have to go back into that jury room and convince yourself beyond every single doubt of the defendant's guilt. That's not what reasonable doubt means. You are authorized to convict him even if you have a doubt. That's what the law is. It's a reasonable doubt. And we're going to talk about that. It's not a mathematical certainty. I do not have to foreclose every other possibility, as Ms. Drake said. You are not searching for doubt. Ms. Drake brought this up at the end of her closing. That is not the job of a juror, to go and search and come up with wild theories that could possibly be true. Right? That's not the job of a juror. Right? As you go back there, if you have reasonable doubts, ones that make sense based on your own common sense, those are reasonable doubts. And it's not vague or arbitrary. It means, and those are legal phrases that we use, but what that means, and you're going to see it in a chart, it means that it can't be something that's just, I can't place my finger on it, but it just seems like maybe there's a doubt, I don't know. It has to be something concrete that you point at with common sense and reason and arrive at. And the point here is that it is based on your common sense. You're going to read that in the chart. Why is that? Because in our jury system, we ask jurors to decide cases for which they've never heard about or seen about, and based on evidence presented solely here in the courtroom. And how do you do that as a juror? Well, you don't walk through that door or that door and check your brain at the door. You are expected. We asked you to be on this jury. We selected you to be on the jury because you each carry with you your own life experiences and common sense, and you are to employ those in the reasoning and resolution of this case. I like to explain reasonable doubt this way. I look at this photograph and I ask, what made these tracks? Is it reasonable to think that a dog walking on the beach made these tracks? Yes, that's reasonable. And why is that reasonable? It's reasonable because I have life experience, and I have common sense, and I have a dog, and I've been to the beach, and I've seen a dog walk on the beach. And in my life, I've watched dogs walk on the beach, and I've seen what happens when a dog walks on the beach, and I've seen the paw prints that a dog leaves on the beach. That's reasonable for me to conclude that a dog made this. But let me ask you, is it possible something else did? Yeah, sure. It's possible that before I took this photograph, I came along with a fake dog leg and stamped dog prints in the sand as I walked along and took this photograph. That's possible. But is that reasonable? When you see this photograph, in your common sense, what's the first thing that comes into your mind? It's that a dog was walking on the beach and left these prints. And you arrive at that conclusion because it's common sense. In much the same way, my children, who made this mess, I am certain that my children would love for me to believe that they didn't make this mess, right? That instead, maybe burglars broke into my house and went up into my son and my daughter's room, messed everything up, and nothing else in the house. They only messed up there. Maybe my children would like me to believe that, right? But is that reasonable? Well, the answer is no, right? And why? Because I know my children, and I know what children do. And I know that when I walk into my kid's room and I see a mess, I can conclude my children did. Right? I wasn't there when it happened. I don't have cameras in their room. I don't have a witness who's going to come and tell me, hey, your son messed up his room. Right? But I reach reasonable conclusions based on my own common sense. Is it possible somebody else did it? Sure. It's possible somebody broke into my home and messed their room up and left and messed up nothing else. But that's not reasonable. Right? And that's what reasonable doubt is. When you're in the back, are there other theories? Are there other things that Ms. Drake would like for you to believe happened here? Sure, there are other things that she has posited out there that she has said. None of them are reasonable. You're going to get some charges on evidence, right? What type of evidence? What can we consider? What can we not consider? Those types of things. There are two types of evidence that you commonly hear. Ms. Drake has talked about some of them: direct evidence and circumstantial evidence. Now, if you ask 9 out of 10 people, tell me what circumstantial evidence means, everybody will discount it. right? Oh, that's circumstantial, completely circumstantial. You can't believe or conclude anything because the evidence is all circumstantial. And I imagine, like me, you may have heard that. You may even have that strongly held belief that that's what it means. But it is entirely something different. In the legal context in the courtroom, that's not what it means. Direct evidence is evidence that can be seen or heard or otherwise directly sensed, such as by smell, taste, or touch. Also hearing. So, things that you've heard in the courtroom, such as witness testimony, the exhibits that you have in the back, all of these photographs, you've got the discs, there's physical evidence, the defendant's gun left at the scene. That is all direct evidence, and you are authorized to consider it. Right? You should consider direct evidence, right? It makes sense. You've seen it, witnesses have testified about it. That's the stuff that you look at and you consider. But you also consider circumstantial evidence. Well, what does this mean? Circumstantial evidence is the proof of facts or circumstances by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. This goes back to the photographs I showed you. I've got direct evidence, in that photograph of the dog prints on the beach, I got direct evidence, I've got the photograph, right? But I want to know what caused it. Well, how do I reach that conclusion? It's based on circumstantial evidence. My own experience leads me to believe in reasonable and justified ways that the dog did it. In much the same way my children in their room. I've got direct evidence of the mess. I've got direct evidence of the toys everywhere, but I've got no video footage or proof. Well, how could anybody arrive at a conclusion if we have to have video of every single thing, right? That's never required, right? It's never required to have video. Certainly, it would have been wonderful to have the whole thing on video. But with my kids, much like this case, I can use my reasoning and reach that conclusion based on circumstantial evidence. Ms. Drake cited to you a charge, and it said that to authorize a conviction on circumstantial evidence alone, the state's theory of guilt, the state's evidence, I have to disprove every other reasonable theory. And that's a charge that you're going to read. It's in there, and it says that. What the charge means, and what Ms. Drake did not tell you, is that situation applies only where the only evidence presented is circumstantial evidence. But that's not the case here. You have direct evidence to consider. You have all of the exhibits. You have your recollection of what every witness said and the notes that you took to help you with that recollection. That's direct evidence. That, in conjunction with the circumstantial evidence, you are authorized to consider all of it. The direct evidence, the circumstantial evidence, and arrive at reasonable conclusions based upon that. Oftentimes I utilize this as an example. This is direct evidence. I don't need much more to know that the dog chewed up the pillow. He is actively, currently in the process of doing it. But how does that change whenever I find this? Right? I don't have a photograph of the dog chewing up the stuff. But I do have some direct evidence. I've got the mess. And I've got circumstantial evidence, which are my reasonable inferences from that evidence. What does all of this mean for you? What it means is that you use your common sense. That's all we're asking you to do. And I hope that as you walked in here and sat down for the first time and started hearing this evidence, that all of this that you've heard makes sense. This is common sense, what happened here. We don't have to go hunting for Bigfoot in the woods here. This is obvious of what happened to Susana Morales. You will use your common sense, but there are some strategies that the defense has used in this case to try to mislead you, to try and lead you astray. There's a quote, they muddy the waters to make it seem deep. All right, what does that mean? Well, if you've ever seen a stream, if you've ever seen a creek bed or a river, oftentimes that water can be very clear and you can see all the way to the bottom. You know just how deep it is, and you know what's on the bottom of that. You know what lurks beneath the surface. You can see it. But muddying the waters, what happens when somebody comes in and takes a stick and stirs everything up so that you can't see, or so that it doesn't appear clear to you. And it's distraction. It's taking your focus off of what's important in the case and coming up with random theories and conjecture that makes no sense in light of this case and in context. There's another defense strategy. This is a red herring. And we may have heard that phrase in psychology or in human reasoning and thinking. What is a red herring? What's an actual fish? Red herring is a fish. And where did this phrase come from? When back in the day, hunters would use hunting dogs to track animals. Foxes, deer, whatever they were hunting, they would use hunting dogs. And oftentimes, in order to train the dogs, hunters would take a red herring fish and they would run it across the scent trail of the animal they were tracking. The whole point of that was to train the dog to ignore the scent of the red herring, because dogs could pick up on scent, and they would follow the red herring trail, and they would not follow the right trail to what they were hunting, right? And that's where the phrase came from. What it is the injection of irrelevant or unsupported facts, in this case, by the defense, that is meant to take you off the path, out of the hunt. It is meant to take you down some side path that makes no sense and hopefully distract you from the truth in this case. For instance, in this case, a focus on Synovia. That's a red herring. You'll hear again here in a moment, but you already heard from the defendant in his interview. She had nothing to do with it. Her phone records and his phone records, she's in Doraville and down at Peachtree Corners while he is out at the scene with her body. There's no questioning of Synovia on the stand whatsoever about, did you do this? Were you involved? Did you kill her? The defendant told you in his interview she had nothing to do with it. She didn't kill Susana. But it's red herring, right? If we can distract you, if we can take you off course to something that doesn't matter, that's just not an issue in the case. Another one, and this is a big one. Drugs. What testimony did you hear about drugs? You heard that Susana liked to smoke marijuana, and she smoked marijuana. You heard the testimony in the case that she had tried a pill one time and wrote about it in her journal and said she didn't like it. And she told Axel, her boyfriend, it made me feel disgusted with myself. That is the evidence of drugs. The rest of this about maybe she overdosed, maybe she died that way, is a complete red herring, unsupported by any evidence in the case. Not a single person told you that she overdosed. Not a single person told you that she even had other drugs that night, or any night other than one time, months and months before that incident. That's a red herring. But these are the defense strategies. And the reality is, when the evidence in the case is so overwhelming, when it points so dramatically to one conclusion, to one person, the defendant, Miles Bryant, as being the only person involved and responsible for Susana's death, what other choice does she have? What other choice is there than to throw out possibilities and theories that have absolutely no support? There is no other evidence. There is no other support and no other conclusion that you can reach, and we'll get to that. I want to take you through a timeline of Susana's murder. What we know about the timeline is that around 7 p.m. she left Raquel's house. Right? How do we know that? Well, her mother, Maria, when she took the stand and said she left, she said 6 o'clock. That was what she said. But the phone records very clearly. She said, I called her about 10 or 15 minutes later after she left to make sure she had gotten to Esmeralda's house. And we all know she didn't go to Esmeralda's house. She went to David's house. And she called her 10 or 15 minutes later. Well, that's at 7:17 p.m. Mom called at 7:17. You heard that evidence, right? You got to see Investigator Wilbanks map out for you that exact call. as it came in at 7:17 p.m. And what it showed very clearly is that she's not at Kelly's house at that time. She's not over at Alyssa's house. She's in the area here of Singleton Road, where Investigator Wilbanks told you would be consistent with her walking down Singleton Road to go to the apartment complex. Right? That's at 7:17 p.m. From 7:28 to 9:58 p.m. We know that based on her Life 360, she is at the apartment complex, and she's with Kelly, and she's with Alyssa, and they're hanging out. They told you she was there with us, right? Nobody's got exact times. Nobody was putting their stopwatch on. I started my stopwatch when I started talking, just so I know how long I'm talking, but nobody does that in real life. They gave you an estimate of how long they thought they hung out, right? Around 10 o'clock, she went home, right? 9:30 to 10, I think is what they said, is what Kelly said. 9:30 to 10 o'clock, somewhere in that time frame. I walked her to the end of the neighborhood, and that's when she went home, right? And that's consistent with her Life 360. That shows her there. We have at this point 9:58 to 10:07. It shows this trip of her walking home, right? And it's at 9:58 to 10:07. What is, and we'll get to it here in a minute, but what is really interesting is, as Investigator Wilbanks talked to you about, this is based on cellular networks, it's based on when your phone picks it up, when it doesn't pick it up, but it shows several different points on here that are relevant, including that she's on Singleton Road, and then she is on Santa Ana Drive, which is where she lives. She is steps away from her home. She is steps away from being home. You saw this. I'm just going to turn the sound off the laptop real quick. But you saw that. Next, what we know is that sometime during that period of time, she disappears. How do we know that? How do we know she disappeared? There's not a single phone call. There's not a single text message. There's not a single social media post, not a comment, not a message to any friends, not reaching out to anyone ever again. The last visible or physical or electronic trace of Susana's life is as she's walking past King David County. That's it. After that, there is virtually no trace of her ever until she's found in the woods. She made it back to Santa Ana Drive. She is literally, Kelly and Alyssa told you, the end of that night, they had a great night. There were no problems. There were no issues. She was walking home. She wanted to go home. They were all going to bed. There was no discussion of her going anywhere else. There was no discussion of her doing anything else other than going home. And in a particularly tender moment, they said, we thought we were going to see her the next day. We thought that we were going to hang out the next day. She made it all the way back to her road before something happened to her. Before she immediately changes directions and ends up back in the defendant's own apartment complex. Alyssa and Kelly told you, they didn't see her the rest of the night. The Detective Carter told you, she knows no one else in the apartment complex. She has no other connections in that apartment complex. There is absolutely no reason that she would voluntarily go back to that apartment complex. There's no prior messages. There are no prior phone calls. There are no prior social media messages. The lifeblood of a teenage girl in communicating with friends and people whom she knows. There's nothing ever in her lifetime connecting her to that apartment other than Alyssa and Kelly. But yet, and here's what's interesting. This trip is a 9-minute trip, 9:58 to 10:07. There is an impossibility for her to get from Santa Ana Drive back to here in that period of time without a car. You saw her walking all the way to Santa Ana. We know she walked to Santa Ana Drive. We know she passed the King David Academy because she's walking. But then almost in an instantaneous moment, she is back in Windscape Village Lane apartments, the Sterling Glen apartments where the defendant lives, where he not testified, but said to the detectives in the interview, he would post up all the time. He'd sit there in his truck and he'd monitor what's going on in the exits and in the parking lots. And he sits there. And she gets back there, it's impossible, walking. Plus, there's no other camera footage. You heard, they reviewed all the camera footage. She didn't walk back past King David Academy. She didn't voluntarily walk back to the apartment complex, but she ends up there. At 10:20, Miss Briggs said, what happened between 10:21 and 10:29? We absolutely know. I absolutely know, because we have the images of exactly what happened. She is traveling at 40 miles an hour down Singleton and Steve Reynolds Boulevard before there is a crash alert at the Oak Block Trace neighborhood. That's exactly what happened. Her phone is traveling at 40 miles an hour. And you don't have to have any specialized training or knowledge to understand the human being can't walk or run that fast. She is in a moving vehicle. You heard testimony from Detective Carter, who has significant experience and understanding of Life 360. You don't get a crash alert by dropping your phone. Everybody told me that. We've dropped our phone. Nobody's ever gotten a crash alert. You don't get a crash alert by braking hard. There were no accidents that time.
Objection, Your Honor. I believe that is misstating the evidence. You can get a crash alert from hard brake. Detective Carter testified to that.
Mayor. So what the testimony, the text message says, it could be from any of those things. What the testimony, and I don't make up evidence, the testimony from the witnesses is that nobody has ever gotten a crash alert from hard braking.
That's my recollection.
But they also introduced the message itself, which says this could be from hard braking.
Yes.
Can I continue, Your Honor?
Absolutely.
The photograph here, and what's interesting about this, Detective Carter testified and told you that what appears to happen up here is a U-turn on Steve Reynolds Boulevard. I'm going to take you to the testimony of Zenobia. She said, I saw the defendant coming back this way on Steve Reynolds Boulevard, and then he turned right here. And that's where she confronted him, right, about the vehicle. That's wholly consistent with him turning around, U-turning on Steve Reynolds Boulevard and coming back. But in any event, at that moment, Susana's phone is thrown from the vehicle. There are no accidents. There are no, she didn't drop it, it doesn't happen. Detective Carter told you of significant importance. The only way you can get a crash alert is that your vehicle has to be traveling more than 25 miles an hour for at least 30 seconds. That's the rules from Life 360. I didn't make them up, they did. And that's what she testified to. So if there are no accidents and there are no other incidents, her phone is thrown from the vehicle. How else do we know that? You're going to see here in a minute, phone records. Her phone never moved again. It stayed there, despite her body ending up 22 miles away. 16-year-old girl voluntarily throwing her phone out of the window because she doesn't want it, and then ending up dead? That doesn't make any sense. What makes sense is the defendant throwing her phone out of the vehicle. And how do we know that makes sense? Because Ms. Drake didn't mention it one time in her closing. That's what she doesn't want you to know. She doesn't want you to think about. No possible version of events that she is attempting to get you to believe can account for the defendant throwing Susana Morales' phone out of the window. It makes no sense. Why would he throw it out? Why would he? It's murder. He doesn't want to be tracked. Those phones can be tracked, and we did. We tracked them, but her phone never moved. It stayed there through 76 missed calls from her mother and her sister and her friends and her boyfriend. And it rang and it rang and it rang. You heard another red herring in this case, another distraction tool, was that Ms. Drake questioned witnesses about the battery being dead. right? There's no way that could be where the phone remained because the battery's dead at 10:30. Well, you've heard numerous expert witnesses testify to you that phone did not die at 10:30 p.m. It died after 6 a.m. And how did we know that? Because her phone records show call after call after call, logging and pinging off the same tower in the same sector, never moving again after 10:29 p.m. We do know that her phone was thrown at that time at 10:29. The crash alert that was received shows Susana at that location at 10:29 p.m. and her phone is never found again. It's never recovered. This is that area at Oak Block Trace where that occurred. What's the next thing that happens? Right? There's not much else that happens that we have documented other than the defendant sending his mother text messages at 11:58 p.m. It's me. Mom told you she never saw him that night. No explanation as to why he sent that text message. I understand. We have a text message. That's the only other text message. That's the only other documented activity. Mr. Willis told you, I went through all his phone records. And for that period of time, now there were other phone records that showed him moving, if you recall the maps, showed him moving a little after midnight from Norcross up to Interstate 85, to Highway 316, past the airport in Lawrenceville, all the way driving out to Tequila, Georgia, 22 miles away from his house. At 12:52 a.m., it shows the defendant in the woods exactly where Susana's body is located. By 12:52, he is in the woods in Tequila, Georgia, where his gun is recovered and Susana's body is found. We know he was there at least 6 minutes later because he's still pinging off the same tower at the same time, or 6 minutes later. Right? You'll recall his changing stories with Detective Carter. He initially said, I never went down 316. I drove around the Norcross area. I didn't go down past Lawrenceville and Highway 316. And then they confronted him with his records. Oh, this does look bad. I did go down Highway 316. That's what he said. I did go down Highway 316. Yeah, I did drive down that way. And yeah, okay, so maybe my phone was around that area. But I just drove. I just drive everywhere. Right? And then you're there for an extended period of time. It's not just 6 minutes. You're in the exact same area. We're at 1:39 in the morning. So he's been there at this point for 47 minutes in the woods with Susana's body and with his gun. That's not it. That shows you right there. And you heard Detective Poppy goes, well, that's not it, right? That can't be, you can't just have been sitting there because we had Detective Carter testify and tell you how long were those calls that he was out on. There was only one of them lasted, it was less than 10 minutes. The other ones weren't even answered. So we got 47 minutes, he's on the phone with Zenobia for less than 10. In one of these 4 calls, right there, where her body's at. 1:46. We're now 7 minutes later. 1:46 in the morning, he's still there. We're almost an hour of him there in Tequila, Georgia, with her body, his gun, in the woods. Again, there at 1:46 a.m. And then the next morning, Detective Carter told you she didn't ask him about this because she didn't have these records yet in the interview. He went back. Mr. Rick told you. He lied completely about the gun. He lied about the gun. He lied about dropping the gun in the woods. And he lied about, he went back. She told you that just a moment ago, that he went back. I didn't need her to tell you that, because we already told you that. He went back at 9:35. And you don't have to doubt why he went back. She told you why he went back. She told you he went into the woods. So despite his repeated Statements of the police that he had never gone in the woods, that he was never out of his truck, that he only stopped parked on the side of Highway 316, that he had nothing to do with this. Complete fabrication. It's an absolute lie. Sergeant Georgetown said it best. That's a bold-faced lie. Everything you're saying is a bold-faced lie in that interview. Shows you here the next morning, back out there at 9:35. Well, what's significant about that? We'll talk to you about that in a moment. But I want to talk about Susana Morales. I want to talk about who she was. What you heard testimony of. Happy. Life of the party. Comic to her friends. 16-year-old girl. And in the prime of her life. She's just getting started. No connection to the defendant. Alyssa Marvin told you that as they were walking out of the apartment complex, the defendant offered them a ride, which they declined. She also told you that she, Alyssa, talked to the defendant at the pool and Susana was there. That's it. She is present 2 times when the defendant shows up. That does not show a relationship. It does not show any communication between the two of them. It doesn't even show that she knew him, ever spoke to him, or talked to him, ever. In fact, Detective Carter went through her phone records, through the defendant's phone records, through the defendant's cell phones, through both of their social media accounts, not one single communication in history between the two of them. Ever. She didn't know him. He was a stranger. She had never interacted with him. There is no evidence, period, that she had ever interacted. In fact, there is evidence to the contrary. There's no communication. Somebody you interact with, somebody you're friends with, somebody you know you're talking to on the phone or through text messages or probably most teenagers, social media. 0. She didn't know. She had never spoken to him. There's no evidence of her ever even speaking to him. She is walking home from her friend's house. That's what you heard. Kelly and Alyssa told you everything was normal with her that night. And yes, she smoked marijuana. And according to the defense, apparently that's somehow justification for murder. That she's smoking marijuana, so she must be a troubled teenage girl. Straight to consider herself like most teenagers who smoke marijuana. That's all that happened that night with her. There's no evidence of her using anything else, of her taking anything else, of anything else ever other happening to her whatsoever in life. Her friends hoped to see her the next day, but when she left, despite communicating and talking and texting with her best friends on the planet, she never sent another message, ever. Not, hey, I'm going to go over here, or I'm going with this person, or this, or that, or anything. There are none on any platform, anywhere. And even if we thought, well, maybe somebody deleted them, they're on her phone records. There's no outgoing messages. There were no outgoing phone calls. She never called another person. She never texted another person or communicated with another human being other than the defendant that night. All of her friends said she would not get into the truck with someone she didn't know. The defendant, she did not know him. He is a stranger. He is what goes bump in the night. He is the one who uses his badge to prey upon innocent girls, which is what he did that night. She didn't know him, and everyone testified there's absolutely she's never gotten into the vehicle with anybody she didn't know. She's never done it. She would never do this. The people who know her best in life, her best friends, and she, as Morales testified, I told you, Rose. No, Alyssa, Kelly, she would not do this. She was in a happy relationship with Axel. He told you. I loved her, and I think she loved me back. They had been going out for a couple of months. Her friend told you she's not that kind of girl. She had no evidence that she would ever go just hook up with somebody else, somebody random, particularly somebody she did not know, that she had never spoken to and never communicated with in her entire life. But yet somehow she ends up completely naked in the woods a few hours later. She was going home. Their theory of something else happening makes absolutely no sense and isn't supported by a single shred of evidence. It's not one thing that they can point to say, this is what she did. This is where she went. There's nothing. She was going home. The evidence that you heard in the case from her family and her friends, as we talked about, that she was happy and healthy, she would not run away. Ms. Drake says, oh, she's run away. She's a deprived child, or she's just somebody who just runs away constantly. Her mother, her sister, all her friends told you that didn't happen. She didn't run away, right? Would she stay at friends' homes? Sure. But her mother always knew where she was. And her sister always knew where she was. Not one time in her 16 years of life has she ever not come home and not told anybody where she was. That's the kind of person Susana was. Not some deviant pothead who was irresponsible and not talking to her mom and running off into the night with strangers. Despite whatever characterization the defense wants to make about her, that is not true. She always told everybody where she was. She didn't know the defendant. She wouldn't get into the truck with a stranger. She was on her way home. And that she had absolutely no reason to go back to the apartment complex that night. Not one. The Gwinnett Police, multiple detectives from the Special Victims Unit and the Gwinnett Homicide Unit told you about searching for her. Not a trace. Not anything about her whereabouts. Canvassing the Sterling Glen Apartments, nobody who ever saw her again. Nobody who ever saw her come back to the Sterling Glen Apartments that they found. Nobody who ever says she walked back to the apartments. None of her friends. She didn't text any of them, didn't call any of them to say, I've changed my mind, I'm doing this, or I'm going here, or I met this person, or I'm doing that. None of that happened. She vanished without a trace. You heard from the medical examiner, Dr. Carol Terry. You saw these heartbreaking photographs of how this defendant dumped and left her body in the woods. Not there, didn't even dig her a grave. Dropped her body in the woods and left her there for animals to take, to eat her flesh. Her family for 196 days, no funeral that they got to give for 196 days. No even knowledge of where she was, if she was alive, if she was kidnapped and being held somewhere, if she was anything. He callously left her body here. You heard about the autopsy. Testimony from Detective Carter and from Dr. Terry. They've never, ever seen a teenager dumped in the woods naked and it wasn't a homicide. Not one time. Dr. Terry, over 30 years of being a forensic pathologist, over, I think she said 6,400, but it might be more than that, autopsies she's conducted, including numerous ones with skeletal remains. The experience that she has is unparalleled in DeKalb County, in Fulton County, in Gwinnett County, and across the metro Atlanta area. Never seen it, ever. And what she did tell me was that she was very suspicious of this being homicidal violence, based on the circumstances of what happened. A 16-year-old girl ending up naked in the middle of the woods in Decula, Georgia, on the side of Highway 316. No way to get there, no messages, no anything. That this is a homicide. She said, I have to be consistent. I didn't find skeletal trauma, so I can't say homicide. I just can't say the word homicide. But it's very suspicious of homicidal violence. There's no way she could have gotten out there to her location. And what's more, and you'll hear yet again here in a moment, the defendant definitively told you this wasn't an accident. If you recall, in the interview that he gave, he foreclosed every single theory, reasonable theory that Ms. Drake is trying to convince you was reasonable. He said it didn't happen. It wasn't an accident. It wasn't an overdose. It wasn't something. It wasn't there. He told you in the interview it wasn't an accident. And what's also interesting, 3.5 hours of hearing from detectives about how his gun is found feet away from Susana Morales, the missing 16-year-old girl. He came into play completely done, but we all know that's a complete fabrication. He had done research on her for the entire 196 days. So he knew exactly everything that was going on, despite playing dumb to the detectives. He never asked one time how she died. He never said, was she shot with my gun? My gun's out there. It's because he knows how she died. Dr. Terry told you, it is particularly suspicious of strangulation. And that's relevant because the DNA, they didn't find DNA in the truck, right? If she had been shot or stabbed in the truck or before and put in the truck, there'd probably be blood everywhere, and you can't hide that. If she had overdosed, there'd be vomit. They found no traces of that, right? It's based on all of that, Dr. Terry told you, extremely suspicious of strangulation, of an asphyxial form of death, strangulation. We found the defendant's gun. You see the photographs, you have the gun, it's his serial number, reported stolen that night. The next night. This is him.
So yesterday, I don't know what time, man. I went running around here. I did a bunch of stuff yesterday, and I came back. I went to the store, and everything. I had it at the store, and I came back. I went running everything, and then my girl was finna leave. I was like, I got my wallet. I don't know where my wallet at. So I can't find my wallet. And then this morning, I worked Doraville. I was getting my dry cleaner. I had to work tonight, and then I looked on my floorboard, and the my Glock 19 holster is on the floorboard, and my Glock 19 is always together, you know. Right. So, oh, I hate to say, I think I left my door. They ain't smashed the window or nothing. I fucked around, left my door on.
A police officer sworn to tell the truth, to uphold the law, wears a badge, has the responsibilities and obligations that come with that. But yet, he's standing there telling another police officer a complete lie, an absolute fabrication. That he left his doors unlocked and somebody came and took his gun. You don't even have to think hard about that one, because Mr. Drake told you that's a complete lie. But he is standing there to another law enforcement officer. This isn't some just last minute cover up. This is him making significant conscious decisions to lie and cover up and create some elaborate tale of what happened that night. This is at 10:30, approximately in the morning, July 27th. And what's important about that? At 9:35, he is in the woods. Less than an hour before he makes this report, he's in the woods looking for the gun. He's out there trying to find it as he dropped it. 9:43, he's already headed back at this point to his apartment complex. By 9:43, he's driving back on 316 past Lawrenceville, goes directly back to his apartment and calls the police to report the gun stolen. Innocent people don't do that. Innocent people don't call the police and make up wild allegations. You know, there's this line in his interview where he's, I wouldn't do this because I wouldn't want to jeopardize my career. That is complete nonsense. Every piece of evidence you've seen in this case is the defendant making a conscious decision not to torch his career. He doesn't care. He wants to use the badge. He wants to use the uniform to do whatever he wants to do, to victimize women. That is the defendant. At 10:30, less than an hour after being in the woods, comes back and calls the Gwinnett County Police Department and sits there, cold and calculated, talking to Officer Merkley. You watch the whole video. Oh, I want to come work for Gwinnett County. Maybe I'll put in a thing, and they're just shooting the breeze. Like nothing ever happened. Absolutely nothing. It's unimaginable. This is at 10:30 in the morning. We're talking about 9 hours before this, he is in the woods dumping a lifeless, naked 16-year-old girl in the woods. And yet 9 hours later, he is standing there just as fine as can be. It didn't affect me. You know what? I'm going to cover up the gun stuff too. And they were absolutely right in his interview. He did it because he knew that if they ever found the gun and he hadn't reported it stolen, he'd be prime suspect number one. But Detective Carter told you it almost worked, right? Because when they found the gun and they ran it and it had been stolen, they thought maybe it was the same person who did it, right? Maybe somebody broke into the apartment complex, in his car, took the gun and kidnapped Susana, right? That was his plan, his calculated, manipulative decisions in order to mislead everybody who might look into his case. And 9 hours later, despite having carried her life or drugged her lifeless body through the woods and dropped it there, he's fine as can be, talking about coming to working for Gwinnett County. Coming to working for, he's at Doraville. He's at the Doraville Police Department, where the chief got him a job because he knows the chief and played basketball with him. But just as fine as can be. It was last night. I was going around. I was going to the store, and then I don't know what happened to it. I had it last night when I was at the store. No, that's a complete lie. All of this is complete fabrication by the defendant. He lied about his wallet being stolen. I mean, for the life of me, the same day he reported it, he used his bank card in McDonald's to buy McDonald's. And again, another red herring. Maybe it could have been Apple Pay. No, it's not Apple Pay. Detective Carter told me she got the same bank account. It doesn't show up this way. He used his bank card. You saw Officer Viat and his body camera video in January 2023. He had his wallet. He had his military ID. He had his police ID. He had all of his cards. He had his bank cards. You saw he never went to replace his driver's license. He's a police officer. You don't have to have a driver's license. You know the law. You can't be driving around without a driver's license. You have to have it on your person. Never asked for a new driver's license. Ever. Complete lies about all of it. His phone records. What they do show is that night when Susana was taken and kidnapped, he was in the exact same area. Same tower, same sector, he's there. Yet, a few hours later, he's in the woods with her body. Her phone's not there. Her phone is back at where it was left, thrown out of the vehicle. You heard this phone call to Esmeralda. He blocked his phone number, his work phone number, his City of Doraville Police issued phone number to call one of the main witnesses in the case to Susana's disappearance, Esmeralda, her best friend. And he blocked, and just so that we can be sure that it's working correctly, he calls his own personal phone seconds before to test it out, to make sure that it is working and that Star 67 is blocking his phone number. He doesn't identify himself as a police officer. He doesn't identify himself as a courtesy officer. He doesn't identify who he is or why he's interested. He just calls up Susana's best friend to pry into what the police know and what's going on with the case. Because this is July 30th. This is 3 days after he murdered her and dumped her body in the woods, that he is calling Esmeralda. As they're posting the flyers, anyone with information, please help. He didn't offer his help. He didn't offer his assistance. He didn't say, let me help look for her. Because he knew where she was. Because he had killed her and brought her out to the woods and left her body there. He called to cover his tracks. He wanted to know what the police already knew, or what the investigation showed, or whether they had found anything. And he's covering his tracks. You saw the download of cell phones. How long does it take a body to decompose? Those are the searches that he's making in his phone. For 196 days, not offering any help in finding her, not telling anybody where she's at, not doing any of that. He's searching for how long does it take a body to decompose? He's researching over and over and over again. Gwinnett County News and unsolved murders and Gwinnett Team Found, right? Those are the searches that he's doing, right? They can stand up here and try to convince you of whatever now, but his own words, his own typing and texting into his phone shows what he's doing during this period of time. Not only that, he is spending a lot of time tracking his own girlfriend. GPS trackers, how to plug them into CRV to her car. He's using the flock, which I'll show you here in a minute, to search for synovia. The overwhelming majority of 845 searches, overwhelming majority. He's sitting in his police car or his truck, and he is tracking synovia. He is looking for cell tower maps and Verizon towers, wanting to know what towers are going to document his locations during this period of time. You saw here, again, searches for Channel 2 Gwinnett. How are you identified by dental records? Days after her body's found. Days after. He's looking up cameras, traffic cameras. Did somebody catch me? Did some camera see me? He made a lot of searches for QT. You saw it in the record. I mean, just scrolling at this record after record of looking at maps that based on QTs and yet, right after he does that, he comes into court or into the interview and plays dumb about QT. I don't know which one I was at. Maybe it was this one. And I don't know. He had researched everything. He already knew that they were coming. At some point, if somebody found the gun, they were going to come talk to him. And he had already done all of that looking. What is particularly interesting here is his Google records. July 28th. And that one is a day and a half, 2 days after Susana's disappearance. Gwinnett County unsolved murders. He's not searching for Gwinnett County unsolved accidental deaths, Gwinnett County overdose deaths, Gwinnett County this or that. He's searching for Gwinnett County unsolved murders. He's also on the same night, hours after he dumped her body there, naked, searching for flock. Going through flock, and as you saw, those records can put you places. Those license plate readers can put you places. And he starts researching. At that time, that's at 4:48 in the morning on July 27th. That's just a matter of hours after he was in the woods. Right after her body is discovered, he starts trying to look up or look at the P2P data sharing. Right as he's searching for all of these other things. This was particularly interesting. A news story unrelated in every way to Susana's death about a different woman who was found in the woods dead. A Duluth man being arrested for a 19-year-old woman found in the woods. And immediately after reading that police story, or that news story, he pulls up his city-issued laptop, pulls up Google Maps, and looks right where he dumped her body. And he's researching that whole area, scrolling around. You saw, hundreds and hundreds of map points there as he's researching the entire area where he left her body, minutes after finding this news story. You saw the flock records. On July 31st, 4 days after he dumped her body in the woods, he's running his own license plate. His own truck license plate. He's using police resources, yet again, in an unauthorized way. He's not allowed to do this, but yet he's searching his own, and then he used that to stalk Synovia, to track her, to know where she's at, to use police resources to track his girlfriend. I want to talk to you just very briefly about his intent and his motive. There is a charge in there, in the charges that you're going to get. It says that the state doesn't have to prove motive. It's not an element of murder. Motive is not an element. Motive is the why. Why did he do it? Why did he kill her? I may have to go my entire life without knowing the answer. And I don't have an answer about exactly what was going through his mind that night. But we got some really good clues as to what it was. The defense wants you to believe that the defendant, some other explanation other than he cold-blooded murdered Susana. Maybe there's something else, despite not being able to point at any evidence of that. They want you to believe that. And we're talking about less than 24 hours after Susana has disappeared. And even less than that, 19 hours after he's in the woods, dumping her body, after he murdered her, he is back on shift as a Doraville police officer. Nobody knows. He's the only one, right? And he's not sitting there contemplating life, and he's not sitting there thinking about, man, I can't believe that just happened. That was crazy, something horrible, terrible. 16-year-old girl is dead, and now she's naked in the woods, and I dumped her body there. No. He walked into QT, and with his badge and his gun and his uniform, goes up to the manager of QT and asks to borrow her phone. But he didn't borrow it to look at his Chase bank account. He started going through her personal, intimate, hidden folders and texting himself videos of her masturbating. Less than 24 hours. The same day. Earlier that same day, he is in the woods with Susana's naked body. Naked, 16-year-old girl. He doesn't even wait a full day, not even one full day, to go and steal sexual videos of another completely innocent woman. Susana was murdered, left there, and instead of showing any form of remorse, showing any signs of this being accidental or something else being responsible, he doubles down on his sexual deviancy and goes and steals sexual videos from Yesenia Lankus. And she testified to you, and I felt bad that she had to go on the stand and watch that in front of you. Those are her private, personal videos. And he thought nothing else about going into her phone and violating her privacy. You heard about Alicia Bates. That's a police officer, y'all. Police officer, a National Guard member, wearing his military uniform, saying that, oh, she invited him over. You can see at the end of this, that door handle remains stuck in a down position. He tried to push the door open so hard, and that door handle wouldn't even return to an upright position. He tried to break into Alicia Bates' apartment, December 10th, 2022. This is after Susana. This is 5 months after he's left her there and her body has been rotting in the woods. He's stalking Alicia Bates. He wants you to believe that, oh, maybe there was some. Where are the text messages? You have there's some right there. Y'all can look at them. Alicia didn't invite him over. In fact, you got to see a screenshot from October 15th of 2022. It's in there. Go look at it and pull it up. October 15th, 2022. There's some text messages between the two of them, and that's one where he says, "Hey, are you home? Let's link up. Let's hang out. I'll be around that area in a little bit. Right? I'm going to be there in a little bit." He had already been there. There's a screenshot of him there an hour before. He showed up unannounced at her apartment. When she wasn't there, he waited around and then texted her an hour later, "Hey, are you going to be around? I'm going to be in that area in a while." No, he was already there. You heard the 911 calls from Alicia, terrified, whispering that she's there with her boyfriend and a gun to defend herself. And why? Because the police never showed up. They never came out there when she called. She told you, they called me, but they didn't even send a car. Right? You heard the dispatcher on the phone, didn't believe her, right? What? And that's interesting. The dispatcher didn't believe her. This doesn't make any sense. It's something else you're not telling me. Right? It doesn't make any sense. Why a uniformed police officer, a officer with the Doraville Police Department, a SWAT member, a National Guard member, would be stalking and harassing this young woman. She didn't invite him over. She didn't lead him on. There are no messages to that. She provided the messages between them. He keeps contacting her and wanting to hang out. And then after all of this is said and done, after he shows up, after the police are called, even the second time now she's called the police, and even after that, what does he do? He uses his police access for GCIC on his laptop to go in and pull Elisha Bates's information. Something that he cannot do. It is a violation of the law to do. He doesn't care about the law. He doesn't care about the law in any way. He said in his interview, I don't like thieves. That's the kind of crime I want to investigate. He is a thief. He steals girls' photographs. He steals their personal identifying information, and he uses his police resources to do it. There's a statement he made in his interview, I wouldn't do that. I have morals. No, sir, you don't. He doesn't have morals. He's not a moral man. He's not a good man. He's not a good officer. He's not a good National Guard member. He's evil. He's a monster and a predator. And he uses his badge and his uniform to do it. Why is Susana found naked? There is absolutely no reason on planet Earth that she should be naked. There's no evidence that she knew and or would ever voluntarily spend time with the defendant, talk to the defendant, have sex with the defendant, hook up with him. She is on her road, steps from her house, before she is snatched up off the street and ends up dead, completely naked. Michael Jones told you. He told you when he got his evidence in the case, went through the evidence, you've seen boxes, we've had boxes, there's been files, there's stacks of evidence, there's all kinds of things. When he got that and he started looking through it, came out of his cell, Michael Jones, and the only comment he had to say was, they can't connect me to the body because they didn't find my blood or semen on her. I'm sorry, what? You didn't find your blood or semen on her? Who says that? Who says that they didn't find my semen on her if you didn't rape her? If there's no chance of it being on there, why would it be on his mind? It makes absolutely no sense. The reality is, Susana's a beautiful 16-year-old girl, and the defendant, who has a problem with preying on women, young women, beautiful women, snatched her off the street and raped her and dumped her body and killed her. And his only comment is that we can't tie him to the body because there's no blood or semen. Mr. Drake told you that the defendant that Mr. Jones came forward before his sentencing on escape. And she's trying to convince you that maybe he had some kind of ulterior motive. That is a lie. Or maybe just a misstatement or misremembrance. I watched it again last night. Mr. Jones said, precisely, when she asked him, did you contact the DA's office before or after your escape? He said after. That's what he said. He had nothing to gain. He had nothing to... And again, Mr. Drake even asked him, well, are you hoping that something's going to happen? What was his answer? Nobody's going to do anything for me. What did he say about me? Mr. Delphine has never offered me a single thing, offered to help me in any way. Mr. Jones has got no involvement in this case. He is absolutely, in every way, unrelated as a non-party. He just so happened to know the defendant in the jail. And the defendant confided in him information that we can't tie him to the body because we don't have his blood or his semen. And then says, when and if I go to prison. When I go to prison. What's it like? They talk about the death penalty. And he says, this is the only one they've got me charged with. The defendant's own statements, his own state of mind in the jail is that he's going to get convicted because he did this. His own state of mind is, can I get the death penalty for this? Because I did this. Right? And when he sees the evidence, is excited that we can't tie him to the body Because he sat there for 196 days not saying anything to anybody, and we couldn't get any DNA or semen. His story, this is what was said in opening. You're going to hear from Miles Bryant. He's going to explain to you exactly what happened. You're going to know the full truth, why Mr. Miles lied to the police and why he reported his gun stolen. That's what was said to you in opening. What you heard was, I have morals, I wouldn't do that. What you heard is that the defendant murdered Susana. You heard from him in his interview.
Did she try to rob you? You did say, listen, just hear me out, okay? When I tell you I got your back, trust me, okay? You said your holster's in the passenger seat, because we've been playing this forever. We got this information last week, but we haven't come and run up on you because we're not worried. We don't think, you know what I'm saying? The holster is in your passenger seat floorboard. Did Susana try to take it?
No, I literally never seen it.
Susana didn't try to rob him.
This is the moment where you're like, okay, yes, I fucked up. That's not what I'm supposed to do. That's not what was supposed to happen. Her and I were together. I know you're stressed out. I'm not going to go tell Doraville you were smoking weed. So you went out there with her to smoke weed and she had bad weed. You know what I'm saying?
I never smoked weed. None, that time, nothing.
Okay.
God, this looks bad.
God, this looks bad. Yes, it does. Here.
Were you trying to help her and she was already dead when you found her?
No.
She wasn't already dead when you found her.
You were involved with her? She's 16. I don't give a fuck what y'all had going on. You talked about all these side pieces you had.
Yeah.
If you had a side piece with her, cool. Just tell us that.
No.
Okay.
No.
He tells you so?
Did your girlfriend kill her?
No.
Could your girlfriend see her and then lose her shit and kill her? Then she go like, oh fuck, my girlfriend just killed her. Let me go dump this body out in the woods.
No.
Reality is, the defendant, during his interview, you heard him. You heard his statements. His version of events to you, the jury, is that he didn't know her. He had never seen her. She was never in his truck. He didn't dump her in the woods. He didn't drop his gun. He didn't do any of those things. Right? Given every opportunity to explain and give some reasonable explanation, no, she didn't rob me. No, she didn't die of an overdose. No, Zenobia didn't kill her. She wasn't already dead when I found her. He has answered those questions for you. They are not reasonable. He said that she was never in his truck.
I literally was by myself. You talking to my girlfriend. When she came up to the front of my truck, stuff like that, nobody was in my truck.
She wasn't there with you.
Who?
Your girlfriend wasn't there with you out there on 316.
No, but when she came at the apartment complex stuff, nobody was in my truck.
Nobody was in his truck. Well, that's an obvious lie. Mr. Drake's already told you he's guilty of the false report of a crime. What does that mean? It means he lied about his gun being taken out of his truck. Well, what does that mean? That means he dropped it in the woods. It had a light on it, and he dropped it in the woods, using it as a flashlight. And if he's out there in the woods with his gun at Susana's body, then he left her there. He dumped her naked body there. You can follow the bouncing ball. It's not hard. His says she was never in his truck. That's an obvious lie. He drove his truck out there with her dead body in it and dumped her out in the woods.
I mean, you were in the woods, literally over her dead body. How do you not see that?
Your gun was right there, dude.
I was out there with your bones and with your gun. Literally just looking. Wow, look at that.
We
Look at that. It's so
consider
close.
ourselves good detectives, but A lot of times we don't find the gun.
I can't.
But when the gun is sitting right there, it's right there.
You want to see a picture again? I took a picture when it was sitting in the woods. There it is. Not buried, not thrown, not hidden. Just sitting there with natural pine straw falling on top like you mistakenly dropped it.
He told you, I didn't make a false report of a crime.
You know, and even as we looked into my car got broken into. You know, when people go grabbing door handles, because you left your truck unlocked, right?
Yeah.
What do? They grab hundreds of door handles. Guess how many entering autos happened that night?
No.
Just yours. 0.
So you said yourself earlier, your complex gets hit all the time.
Yeah.
Multiple people. How is it just convenient for you that your truck is the only one that gets broken into in the back of the complex? We're not stopping at any other building along the way. They're going straight to Miles's truck, and that's it. Because that was a false report of a crime.
It was not.
Because you dropped your gun in the woods.
No, I didn't.
I think you were using your weapon light as a flashlight to figure out where you're going to dump her.
No. I have plenty of flashlights. I don't know. I wouldn't even do that.
Yet, here today, you heard the exact opposite of that. You heard, he did do that. He made a false report of crime. He said, no, I didn't. The straight told me, yeah, he did. Yeah, he did. And it's obvious. And which is why she said it. Because to stand up here and say he didn't in the face of the overwhelming, monumental evidence that he did is just absurd. Right? So I get the defense strategy, right? I've got to stand up here and admit what I have to because it's undeniable, but then try to convince you that everything else is a lie, right? That everything else in the case is a lie. The one thing that is, the 100%, I'll admit that. But the rest of it, try to mislead you that that's not true, right? That maybe some mystery thing happened that there's no evidence for. The defendant told you.
Well, you have some sort of part in it. There's no other way you could have all this on this incident. There's no other way unless you have a part in it.
I have no part in it.
It's impossible.
That's a bold-faced lie.
He also told you he didn't even know where Susana lived.
Do you know where, Susana didn't live in your complex, but do you know kind of where she lived?
From what I've seen, she lived nearby.
Like where?
I have no clue. It said she was walking home and I don't know. She said she lived nearby. So I guess it'd be in the area. I don't think she lived in that apartment complex though.
Mm-hmm.
And Ms. Drake brought up the fact in that previous clip, he slips up. He slips up and says, she said that she lived nearby. And his evidence for, they must have had a conversation. And I didn't say that they did. Ms. Drake said, in order to kidnap somebody, you just got to snatch them up out of the car, off the street. You just got to stop your truck and violently drag them into your vehicle. No, you don't. Did he offer her a ride to her house? I don't know. There's no evidence of that. Did he talk to her? We don't know. There's no evidence of that. Right? What we do know is that once he encountered her, she never saw the light of day again. He snatched her up at some point and drove off with her, threw her phone out of the window, and killed her and dropped her lifeless body in the woods. That's what we know. And that there's no other reasonable explanation for his conduct that night. I created a list of the defendant's lies, and I had to create a list because there were so many. I couldn't count them on my hands. So I wrote them down.
Wow, prosecution is.
I didn't go into the woods. That's lie Number one, I didn't stand over her body. That's a lie. I didn't drop my gun. That's a lie. My truck was broken into. That's a lie. My truck was unlocked. That's a lie. My holster was on the floor and wasn't, somebody took the gun out of my holster. That's a lie. My wallet was taken. That's a lie. I never got out of my truck. That's a lie. We showed you the physical activity sensors on his phone. As Susana is walking home and disappears, he's walking around. He told the police he spent the entire night in the truck. He said he drove around all night. He even said when he was doing reports later at the QT, he was sitting in his vehicle. Never said he got out of his vehicle, not one time. On the side of Highway 316, sitting in his vehicle. Yet hour after hour after hour, it shows him walking. And it shows him traveling hundreds of meters, consistent with him dragging a body through the woods in the middle of Tequila from 1 a.m. to 2 a.m. on the 27th, from midnight to 1 a.m. on the 27th. He is moving. He is not sitting in his vehicle. As Susana is walking home at 10 p.m., he gets out of his vehicle and he is walking around. He is a liar. He did not stay in his vehicle. No one was in my truck. That's a lie. My license was stolen. That's a lie. I called police when I found my wallet. No, he didn't. Detective Carter told you there isn't a single call to the police department documenting that he ever reported he found his wallet. Moreover, he said in the interview, well, I lost Officer Merkley's card. I don't know what happened to it. They found it in his truck when they searched it right there. Officer Merkley's business card with the case number for the stolen report. He didn't lose it. He didn't want to call. He didn't call. That's a lie. I didn't dump her body. That's a lie. I wouldn't jeopardize my career. Obviously a lie. I didn't throw her phone out of the window. That's a lie. I didn't make a false report. That's a lie. I didn't know that girl. He obviously is lying. He picked her up that night and killed her. I've never seen her. I had nothing to do with this. Nothing happened between us. I don't know where she lived. I wasn't in front of her house. Yes, he was. His vigilant records show him parked right the next door of her house. Stopped, stationary, parked a month after her disappearance in front of her mother's house. As her mother still didn't know where she was, he is out there, stopped in front of their house. And they told you when they testified, we saw a black truck, it would come back and around there, and he's parked there. My personal phone was dead. Why'd you use your work phone? Well, my personal phone was dead. Garbage. It's a lie. It wasn't dead. He used it all night long. It maps him everywhere. He's calling people on it. That's a lie. I didn't take her clothes. Where are they? They're not with her. He disposed of her clothes. He threw them away. Did something with them to obscure the crime, not be found. I didn't try to break into Alicia's house. That's a lie. I wasn't stalking Alicia. That's a lie. I didn't hide my face. We just watched the video. Police officer, military man, walking past her apartment with his hand like this over his face, trying to open her door. It's lie after lie after lie, but yet he sits there and they are asking you to believe them now. Sergeant Poppy said it best. If you can't tell us now what happened, how is any jury going to believe you? You can't get up here at trial. You can't argue stuff now when justice is about to be served upon you that none of this happened and that there's other possibilities. He was given every opportunity. He was given every measure to explain if anything else happened. He did not. He sat and lie after lie after lie after lie. He has never told the truth, and he's not telling the truth now. They are not being truthful to you. Susana Morales was murdered. There's no other explanation. Nothing else makes sense. She didn't know him. She wouldn't get into the car with him. She wouldn't have sex with him. How did she end up naked in the woods? There is a principle that I talked about, Occam's razor. It means that the simplest answer is usually the right one. In this case, there is a simple answer. There is a simple answer as to what happened. And I'll tell you, the defendant had already thought about doing this. You saw these videos.
Something was happening to you. We're doing a rape or a missing person, then we find your body out there in the woods. Then what? Because I know you're probably strong and you're smart and you know say no to strangers and stuff like that. But nowadays people don't care. People are my size, big, and just come snatch you up. You can scream, you can shout all you want. They're gonna throw you in the back of the van and go take you, and your parents will never see you again. And there's nothing you can do. You can't fight it. I mean, you strong. I promise you. I bet you're strong, but you're not that strong.
Yeah, I know.
There's people that's bigger than me out there. See how bad this can go? Say you was over there with your friends here. Your friend mom knew because she said her kid can go. You get raped and killed, stuff like that. Well, she was the last person to know. So now we're all in her, talking to her like, especially being 13 under the age of 16, you're not even old enough to consent. See what I'm saying? I know I'm getting kind of, out of the bounds, stuff like that, but you're not even old enough to consent for sex yet. You're under 16. You know what I'm saying? You see what I'm saying, though, you know?
Yeah.
I'm being real with you because I don't want you to go ahead and get hurt.
Yeah.
I'm going to get you another phone. What if you was out there and something happened, you need to call, you can't. You know, you just scream, and then they cover your mouth up. 2 months before the defendant kidnapped and murdered Susana Morales, he had this conversation with a missing 13-year-old girl in Doraville. And the obvious fixation that he has with kidnapping, and it's not just, somebody might hurt you, somebody might harm you. It is somebody might snatch you up, put you into a van, kidnap you, drive you into the woods, rape you, and murder you. That's what he said 2 months before. He did exactly that. He picked up Susana Morales. He kidnapped her. He took her against her will. To make sure nobody could find her, he threw her phone out of the window. He then threw her in the back of the truck, drove out to Decula, where he raped and murdered her and left her in the woods. You can hear it from his own mouth. This was not something he hadn't thought about, something that hadn't occurred to him. The reality is that the defense told you that you're going to think he is the most callous, uncaring coward that you have ever seen. And I suspect that's true. And asked you to hold him guilty and responsible for the death of Susana Morales. That's what the defense asked you to do. I'm also asking you to do that. There is no reasonable explanation. There isn't one that makes sense based on your common sense. When you look at this evidence, when you consider what happened the night of July 26th of 2022, the simple answer is the right answer. And you know, and you can see the behavior of the defendant. We don't have to wonder. We've got to see in the trial. Obsessed with stealing videos from this girl's phone, obsessed with stalking his own girlfriend, monitoring her, watching her with hidden cameras, obsessed with showing up at another girl's home who is not bathed, trying to break into her apartment, coming back multiple times, over and over again.
using his police resources to stalk women, using his police resources to stalk Elisha, his own girlfriend. They told you. Zenobia and Avion told you. He's a master manipulator. He comes up with excuses for everything. Right? Time after time, you confront him. Well, what about this? What about that? And it was always some excuse. There was always some little thing that he would give them to make them think that, maybe he's telling the truth. But time after time after time, every time he was lying, living double lives. He is a master manipulator. He is a liar, but don't let him manipulate you. There is no evidence that anything other than he murdered Susana Morales that night. That he kidnapped her, that he threw her phone out of the car, raped and murdered her, and left her in the woods. I'm asking you to do your job. Asking you to look at the evidence, to use your common sense, and to see through the manipulations and the lies and the red herrings and all of the other distractions that they're trying to throw at you, and look at the case and hold him guilty for the death of Susana Morales, which is malice murder. He intended to kill her. He took her, he snatched her up, and almost immediately threw her phone out the window. That makes no sense. No version that they've attempted to present to you, no other alternative explains that. It can't explain that, which is why they didn't mention it, because it cannot be explained. Why is her phone thrown out of the window? That makes no sense. How does she end up naked if this isn't murder? You've heard from all of her friends and who she was. She's not getting into his truck. She's not having sex with him that night. That didn't happen. She didn't want to do that. That's not her character. She was walking home, steps away from her house, and her life was altered like that because the defendant is a monster. He's a predatory monster with a badge. I'm asking you to hold him accountable. I'm asking you to find him guilty. Find him guilty on malice murder. Find him guilty on felony murder. He kidnapped her and she ended up dead. We know that. That's indisputable. She is dead in the woods because of this defendant and his felonious actions. Count 3, kidnapping, he did take her. It was against her will. He didn't use lawful authority. And during that, she got injured. She got killed. Criminal attempt to commit rape, because there is no semen left at the scene. We had to charge criminal attempt. I would have loved to have been able to charge it for his rape. But I'm stuck with the fact that he let her stay out there for 196 days and for her flesh to rot off her bones so that nothing could be done. And no traces of the forensic evidence could be done. Count 5, false report of crime. Already admitted that one. But even despite that, it's overwhelmingly obvious that he lied about that and that he is the one responsible. There is no one else. There's nobody else to hold accountable. There's nobody else involved. There's no evidence of anyone else involved. There's nothing. It's solely the defendant in this case. And I'm asking you to hold him accountable for what he did, which is kidnapping, murdering Susana Morales. Thank you.
Ladies and gentlemen, we're going to take a 15-minute comfort break, and then we'll go over the jury charges, and then we'll release you for lunch. I think that's the most efficient way to do that. So let's take a 15-minute comfort break, and you should be able to get to lunch by 12:30.
Emmanuel, you're right. He did a phenomenal job breaking this creep down. Ooh, I just love it. I just love it. But I really, y'all hear me? Y'all can hear me, right? Let me know. Let me, Okay. Yeah, saying, I love what prosecution did. He did a phenomenal job. Defense, I have to say something about defense. I mean, it's so hard to defend creeps like this because you got too much evidence against him. But he was supposed to be going on the stand, but I guess he changed his mind. After all this evidence that came up, he probably was like, they gonna tear me up. Yep, prosecution was gonna rip you. They was gonna rip you. Yes, they were. We was gonna have fun with that. That was gonna definitely be a Crunch and Munch live stream. Just seeing you on the stand looking like a fool, stalking all these women, stalking women, and this dude is crazy. This guy, he had a 2-year relationship with where we at? Where we at? The girl up on top, her. In a 2-year relationship with her, long distance. She's away in school. She thinking he loyal and faithful to her, and she being loyal and faithful to him, while he over here with this other woman in this picture here, the one at the bottom. He have a whole woman in his bed living with him at the same time. While he's over here, unaliving this one, and then he's stalking another girl. The girl at the bottom. He was stalking her. Breaking in the house. This is crazy. The signs had to show there was something wrong with you since middle school. But people just swept it up under the rug. And the nerve of you to become a police officer, to take advantage, watching these girls offering them drugs and alcohol. Why are you offering minors drugs and alcohol? Are you kidding me? Early 20s, you just ruined your whole life because you were deviant. And I think these women still love you. No, not this. Where's the other women at? Where they at? Oh, it's a 15-minute break. It's called a comfort break that they're giving or whatever. Let me change the banner so people won't. Yeah, they're on a 15-minute break. That's why I'm doing all this talking. What was I about to say? Oh, darn it, I lost track. Oh, well, lost track what I'm about to say. Okay, and let's see. B dash, I see you. Did y'all see the body cam responding to that runaway? He don't even sound like a cop. I'm gonna do later on tonight. I think I'm gonna do the body cam or the interrogation, because those two had to watch. I didn't get a chance to watch the whole body cam. Watch some of the interrogation and everything. But tonight I'm gonna do one of them. Then the other day I will do the other one, body cam or interrogation. What did he say? Why is a 22-year-old a cop? Yeah. But I think it's because he went out. This is my thought, B-Dash. I could be wrong. I think because he was in the military. So, your military come out, they look at you as an honorable, stand-up guy. And so, made him a cop. Crap. All right, what does Melanie have to say here? Where we at? Hold a second. Where we at? Melanie said, yes, he did. Went in order and showed all the holes in the defendant's story, explained the charges. That's why, Melanie, if he would have took the stand, he would have tore him up. He probably was waiting to say, yes, I want to get this man on the stand so I could make him trip on everything he says. Mm-hmm. All right. He came off as goofy. That's how he dropped his gun. Oh, yeah, because Strain, like, why did you drop the gun? That poor girl going home, and here come this creep cop. Creep. You and Nathaniel Rowland. It was a Rowland? Yeah, the other trial that I covered, both of y'all two need to be in the same cell together. Getting jumped every day. Oh, it was the other trial, B-Dash I had covered, and this trial was the Uber driver. Pretending to be an Uber driver when he wasn't. The girl she had a few drinks, she was out with her friends, and she got in the car thinking it was her Uber, and you know the rest of the story from there. Both of them, dusty, low-life creeps. He was a budding serial. Yes. Oh yeah, this wasn't gonna be his first. Then calling the victim's parent, sister. Oh, he said, can't believe he won't. I can't believe he went to my high school. Oh, thank you for your feedback. I love all your feedback and your feedback to my videos. Wow, this is crazy. But there's so many of these creeps out here. Yep, they out here. What a shame. Yep, weirdo. Yes, he is. Gosh, you got all these women over here loving you, want to be with you. I don't know why. I don't see what they see in you. But hey, everybody, what you like is what you like. And you don't care. You got this woman over here, 2-year relationship, long distance. She all in love with you, faithful and true to you. While you have a whole woman in your bed at home, living with you. And then you're stalking another woman. Then you're offering drugs and alcohol to minors. And look where it got you. Look at you. You look pathetic. You look so pathetic. I know if you was my son, I wouldn't support you. All this evidence, especially that video clip of you going to that woman's door. Where's she at? That clip. What was that picture? Where's she at? The girl at the bottom. I don't know everybody's name on here, so the one at the bottom. She was terrified, and the 911 caller treated her the way she did. I hope she got some sort of lawsuit going on, because you shouldn't have been treated that way. And you could tell she's still traumatized to this day. She's still traumatized. All right, where we at? They only liked him because he was a cop and had an apartment and a car at 20. You bingo. You broke it down. You're right. They only liked him because he was a cop and he had an apartment and a car at 22. Great point. Because sure wasn't the looks. Sure, it had nothing to do with the looks. All right, I'm gonna have it on mute for here. Let's turn the music down. Have it on mute until it comes back on. Well, you hear music. We'll see what comes on. Oh, and thank you everybody for being here. Thank you for engaging. And if you didn't hit the like, please hit the like. And if you didn't vote, please vote. Matter of fact, let me read the vote now. Let's see what we got so far. Didn't start yet. All right, I put up a poll, and the poll says, do you think this Creep Cop Miles Bryant will be guilty? 89% said guilty, 0% said not guilty, and 11% said not sure, Donna. All right, back to it. I'm gonna show a quick clip while we're waiting for for them to be off of recess. A short little news clip. Let me show that one. Okay, this is him when they asked him if he wanted to testify.
Are you Miles Bryant?
Yes, ma'am.
All right. Do you understand that you have a right to testify, Miles Bryant?
Yes, ma'am.
All right. Do you understand that you have a right to testify and that if you want to testify, then no one can prevent you from doing so?
Yes, ma'am.
Do you understand that no one can make or compel you to testify?
Yes, ma'am.
Do you understand that you have the right to not testify if you do not want to?
Yes, ma'am.
Do you understand that it is your personal decision, not your lawyer's decision, whether you choose to testify or choose not to testify?
Yes, ma'am.
Do you understand that if you do not testify, I will instruct the jury that your decision cannot be used against you?
Yes, ma'am.
Are you aware that this is the only time you can testify during your trial?
Yes, ma'am.
Do you understand? Sorry. Are you aware that once the verdict comes back from the jury, you cannot change your mind about testifying? Okay. Do you understand if you choose to testify, you will be both examined by your attorney and the prosecutor?
Yes, ma'am.
Do you personally, Miles Bryant, want to testify or not?
No, ma'am.
Okay. I find the defendant has freely and voluntarily decided not to testify with a complete understanding of his rights.
Yeah, that was a clip yesterday. He said he did not want to testify. All right, let me go back to it so we won't miss anything. It didn't start yet.
Full copy of everything I read, so you don't have to take notes. You can if you would like. And then after I read the jury charges, then I'm going to recess you for lunch, and then you can come back and begin deliberating. We'll have all the evidence back in the jury room. Okay? You are considering the case of the state of Georgia versus Miles Bryant. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false report of a crime. The indictment reads as follows. In the case of 24B 00156-4, State of Georgia versus Miles Bryant, bill of indictment, count 1. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charged and accused Miles Bryant with the offense of malice murder for the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury, did unlawfully with malice aforethought cause the death of Susana Morales, a human being, in a manner unknown to the grand jury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. The grand jurors aforesaid in the name and behalf of citizens of Georgia charge and accuse Miles Bryant with the offense of felony murder for that the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury while in the commission of the offense of kidnapping, a felony, did cause the death of Susana Morales, a human being, in a manner unknown to the grand jury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3. The grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse Miles Bryant with the offense of kidnapping for that the said accused in the county and state aforesaid on the 26th day of July 2022 did unlawfully abduct and steal away Susana Morales without lawful authority or warrant and held such person against her will, said act resulting in bodily injury to Susana Morales, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4, the grand jurors aforesaid in the name and behalf of the citizens of Georgia charge and accuse Miles Bryant with the offense of criminal attempt to commit rape for that the said accused in the county and state aforesaid between the 26th day of July 2022 and the 27th day of July 2022, the exact date of the offense being unknown to the grand jury, did knowingly and intentionally attempt to commit the crime of rape in that the said accused did kidnap Susana Morales, an act which constitutes a substantial step toward the commission of said crime, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 5. The grand jurors aforesaid in the name and behalf of citizens of Georgia charge and accuse Miles Bryant with the offense of false report of a crime for that the said accused in the county and state aforesaid on the 27th day of July 2022 did willfully and knowingly give a false report of the crime of theft by taking to William Merkley, a law enforcement officer with the Gwinnett County Police Department, contrary to the laws of said state, the good order, peace, and dignity thereof. Dates immaterial. The indictment in this case does not state that the date of the offense is a material averment or element. Therefore, it is sufficient that the state show that the offense occurred prior to the filing of the indictment, regardless of the date listed in the indictment. Issue and plea of not guilty. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize the conviction of the defendant. Jury, judges of law and facts. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is a means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into the court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, The proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. Credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Expert witness. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon their training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Witness attacked. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to attack, cast doubt upon, or challenge the credibility or believability of, or cause you to disbelieve any such witness. This would include evidence of proof that the witness has been convicted of the offenses of escape, aggravated assault on a peace officer, theft by receiving, theft by taking, interference with government property, burglary, and possession of a firearm by a convicted felon. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statement and testimony when compared to the same witness's trial testimony. As with all issues of witnesses' credibility, the jury must apply your common sense and reason to decide what testimony you believe or do not believe. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Defendant's choice not to testify. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Statement of defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent defendant was informed of his or her rights as discussed below, if applicable. Circumstances of a statement. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. Burden of proof as to rights. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Conditions precedent to consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for purposes of attacking the credibility of the witness or impeachment. Constitutional rights. If you find that the statement was made while in custody and a result of police questioning, you must also determine whether the defendant was advised of his or her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights the law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had a right to remain silent. 2, the defendant chose not to remain silent. Anything he said, wrote, or signed could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have a lawyer present with him at all times during any questioning. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. Burden of proof as to rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given and they were understood and knowingly given up by the defendant. Other crimes, wrongs, or acts. Sometimes evidence is admitted for a limited purpose or against some parties and not others. Such evidence may be considered by the jury for the sole issue or purpose against that party for which the evidence is limited and not for any other purpose. In order to prove its case, the state must show intent. The state has offered evidence of other acts allegedly committed by the accused to prove intent and motive and negate any defenses of accident or mistake. To do so, the state has offered evidence of other crimes, wrongs, or acts allegedly committed by the accused. You are permitted to consider that evidence only insofar as it may relate to that issue and not for any other purpose. You may not infer from such evidence that the defendant is of a character that would commit such crimes. The evidence may be considered only to the extent that it may show the elements or issues that the state is required to prove in the crimes charged in counts 1, counts 2, counts 3, and count 4 in the case now on trial. Such evidence, if any, may not be considered by you for any other purpose. Before you may consider any other alleged acts for the limited purpose stated, you must first determine whether it is more likely than not that the accused committed the other alleged acts. If so, you must then determine whether the act shed any light on the elements of the offenses or issues for which the acts were admitted in this crime, in the crimes charged in this indictment, in this trial. Remember to keep in mind the limited use and the prohibited use of this evidence about other acts of the defendant. By giving this instruction, the court in no way suggests to you that the defendant has or has not committed any other acts, nor whether such acts, if committed, prove anything. This is solely a matter for your determination. Identification and reliability. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all the factors previously charged to you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: number one, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. 3, the possibility of mistaken identity. 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator. And number 6, the length of time between the crime and the out-of-court identification. Identification burden of proof. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as a perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in the bill of indictment. Definition of crime. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and an intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by statute. No presumption of criminal intent. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumptions and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and proper probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge. Knowledge on the part of the defendant that the crimes of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false report of a crime were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crimes must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that crimes were being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of alleged offenses, your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes of malice murder, felony murder, kidnapping, criminal attempt to commit rape, and false reporting of a crime being committed, and that the defendant knowingly and intentionally participated or helped in the commission of them, then you would be authorized to convict the defendant. Guilt by mere presence. A jury is not authorized to find a person who was merely present at the scene of a commission of a crime at the time of its perpetration. Excuse me. Let me start again. Guilty by mere presence. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Venue. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution, in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. Required use of conjunctive language in indictment. When a defendant is charged with the violation of a penal statute containing the disjunctive or separating several ways or methods of a crime may be committed, the indictment must charge such ways or methods with the conjunctive and if it charges more than one of them. Accordingly, at trial on such an indictment, it is sufficient that the state prove any one way or method of commission of the crime beyond a reasonable doubt, and the state is not required to prove all such separate ways or methods alleged in the indictment. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Offenses charged. Malice murder. For malice murder, the state must prove that the defendant, number one, caused the death of another person, number two, unlawfully, and number three, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandonment and malignant heart. Abandoned in a malignant heart, excuse me. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do so, that is enough for the killing to be murder. Felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Kidnapping is a felony. I will define kidnapping for you shortly. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the kidnapping, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Kidnapping. For kidnapping, the state must prove that the defendant, number one, abducted another person, number two, without lawful authority or warrant, number three, held that person against her will, and number four, that the person was physically injured. To constitute kidnapping, the abduction must involve moving the alleged victim. That movement can be slight, so long as it is not merely incidental to another crime. Movement is not merely incidental to another crime if it conceals or isolates the alleged victim, makes it substantially easier to commit the other crime, lessens the risk of detection, or is done to avoid arrest. The injury may be minor, but it must have occurred during the kidnapping. It does not matter if the injury occurred at the beginning of the kidnapping or after the person was abducted. Criminal attempt to commit rape. A person commits criminal attempt to commit rape when, with intent to commit rape, that person performs an act that constitutes a substantial step toward the commission of the crime of rape. For rape, the state must prove the defendant had, number one, carnal knowledge, number two, of a female, number three, forcibly, and number four, against her will. Carnal knowledge means sexual intercourse, which is any penetration, no matter how slight, of the female sex organ by the defendant's male sex organ. Force means acts of physical force, threats of harm, or intimidation. Against her will means without her consent. False report of a crime. A person commits false report of a crime when the person willfully and knowingly gives or causes a false report of a crime to be given to any law enforcement officer or agency. This court has no interest in this case. By no ruling or comment that this court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. Sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. Deliberations. One of your first duties in the jury room will be to select one of your number to act as foreperson. The foreperson will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. Verdict generally. You will have a verdict form with you in the jury deliberation room. If, after considering the testimony and evidence presented to you together with the charge of this court, you should find and believe beyond a reasonable doubt as to count one that the defendant Miles Bryant in Gwinnett County, Georgia, did on or about July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of malice murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of malice murder, or if you have reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count two that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of felony murder as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense of felony murder, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of this court, you should find and believe beyond a reasonable doubt as to count three that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of kidnapping as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of kidnapping, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count four that the defendant Miles Bryant in Gwinnett County, Georgia, did on or between July 26, 2022 and July 27, 2022, the exact date of the offense being unknown to the grand jury, commit the offense of criminal attempt to commit rape as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of criminal attempt to commit rape, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count five that the defendant Miles Bryant in Gwinnett County, Georgia, did on or about July 27, 2022, commit the offense of false report of a crime as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of the offense of false report of a crime, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Unanimous verdict. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Any jury communication to the court from this point forward must be in writing. The parties must be informed of the content, and the writing must be marked as an exhibit and entered into the record. The court must allow counsel to suggest appropriate responses. The court must inform counsel of intended response of the court. The court must allow opportunity for counsel to respond. Again, you will have a verdict form with you. And after you return from lunch, you may retire to the jury room, but I don't want you to begin your deliberations until you return to the jury room, receive the indictment and any evidence that's been admitted in this case. Does the state have any objections to the reading of the jury charges?
Judge, do we approach?
Yes.
All right, let's take a good look at this clown. Just look at him. You know you did wrong, you piece of crap. I can't stand him. I really can't. Stalking women. Unaliving. Only 20-something years old. Ain't nobody gonna tell you different.
Attorney's approach again.
Okay, can someone help me? What time did they say they're gonna come back from lunch? They going on lunch, right? Because they going to lunch. I might end up coming back and do it again. Did anybody catch it? What time they said be back from lunch? Oh, they go to Creep. Something wrong with you. Your parents ain't pick up on it in middle school? You had to have some sort of signs. But how did you pass all these psychological tests? Don't you got to take it for the military and as an officer? How did you pass it? Man, they usually do pass it, right? Mm-hmm. Especially sociopaths. They're excellent. They'll pass any test. I guess they're not going to lunch yet. I don't know what they're doing. I'll just let it keep running for now. See what happens.
Would be, we, the jury, find the defendant not guilty. With that, I'm going to release you for lunch in the jury lunchroom, and then we will come back in jury deliberation. All right. Thank you.
Sorry, I had it on mute on that and missed the last part. Okay, what Emmanuel said. Emmanuel, they don't care. They just want drones that will mindlessly follow orders. Okay, Melvia said they just want to make sure that you can follow orders and not kill your fellow officers. Soldiers, excuse me. Interesting. All right, I was talking so much and wait for the key. What time did they say they coming back from lunch? How long was lunch? Anybody know? Did they catch it? Catch it, catch it, catch it. Someone tell me, someone tell me. Anybody gonna tell me? Did they? Oh, I have to rewind it. Let me rewind it. And go back a little bit here. Let's see what you're saying.
Read, the charge on kidnapping, there was a typo, and I'm just gonna reread it. If after
Yeah, I don't think they did either. But I'm just going to fast forward this. I'm just going to repeat this last part again. Because I think I'm going to cut it off and then come back live again. Because they're going to go lunch. That's like an hour or so. All right.
considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt as to count as alleged in the indictment, you would be authorized to. Thank you. Did on or about July 26, 2022, commit the offense of kidnapping as alleged.
Oh, well. All right. Well, ladies and gentlemen, I'm going to end this. And I'll come back if they, when they come back from lunch or whatever, like verdict or something, and go for that if I can. But most likely I'm going to be doing commentary this evening on this clown. Now, I don't know if they're going to do the verdict today, because if you look at the time, I don't think it's going to be today. Probably be tomorrow, but I don't know. The jury might be like, look, we don't have to be here forever. He's guilty. He did it. He know he did it. We're done. Let's all go home. I don't know. But I will do something this evening, and it will be the body cam. So we're going to get into body cam. So I didn't get a chance to watch that whole body cam. And that's it. But I might come back after this one and see. We'll see what happens. All right, ladies and gentlemen, thank you for being here. Thank you for engaging. I appreciate it. And with this trial, this poor girl, and there was going to be way more victims. And this poor girl at the bottom, he was just stalking you. And that 911 call, I think you might have a case. Get yourself a good lawyer. All right, ladies and gentlemen, that's just it. Everybody, stay tuned for some more, and we go from there. You too, Emmanuel. You too. Adios.